seated. First argument we have, we'll make this so you can hear me. The first argument we have on our docket this morning is styled concerning the application of water rights of Donald E. Dill. It's not entirely clear to me from these orders how we were going to divide up time, if we are going to, and that would be with regard to the appellees. How are you all planning to use your time?
Your Honor, my name is Emma Schultz, representing the State Division Engineers, and we plan to, after we go, and I plan to split our time approximately 15 minutes each.
Okay, so you'll both argue, and you will watch your own time then to do that. All right, looks like all counsel are ready and at your tables. When counsel for the appellants are ready, please begin.
May it please the court, David Schode on behalf of Yamasaki Ring LLC. For brevity and so I don't get tongue-tied, I'm going to simply refer to Yamasaki Ring as just Ring throughout these proceedings here today. We're here on the consolidated appeal in two separate cases. Both cases originated before the District Court in Water Division 2. The issue on appeal before the court today is whether the water court erred in ruling that the Campbell Ditch water rights have an unenforceable entitlement to a series of springs that were in the 1909 decree establishing these water rights. The issue on appeal is identical in both cases. It's Ring's position that these springs are an enforceable source of water decreed to the Campbell Ditch water rights. Accordingly, Ring requests this court to overturn the water court and determine that the Campbell Ditch water rights have an enforceable entitlement to these springs. The water rights that we're talking about today were originally adjudicated by the Fremont County District Court in a decree that we've referred to as the 1909 decree. That's the date of the decree. In that decree, the Fremont County District Court awarded to Horton, W.S. Horton, 2.34 CFS with an 1883 priority date and an additional 2.3 CFS with an 1890 priority date for the irrigation of 100 acres owned by Horton. That decree goes on and states that it is further adjudged that the Campbell Ditch is entitled to conduct and receive from a certain spring and all springs along the line thereof. The appeal and all of the argument that we're going to discuss today focuses on the interpretation of this language. What does it mean?
Sorry to interrupt. Can I ask, why do you think that the order at that point specified the amount of the enforceable right as to the first two rights, but said nothing about the amount of the enforceable right or any of the other particular details as to the certain springs?
I understand the question. When you read the decree in its entirety, we clearly have an appropriation for the two senior rights. Let's call them the two Cherry Creek rights, or it's been referred to as the Campbell Ditch and
The ones that are defined as required by the statute at the time?
Correct.
Okay.
So when you read the specific language in the decree, it says it is adjudged that said the Campbell Ditch. That language there, the Campbell Ditch, what we're defining as the Campbell Ditch, is the 2.34 CFS with an 1883 priority and 2.34 CFS with an 1890 priority for the irrigation of 100 acres of land owned by Horton. So that's a defined term. I mean, everybody agrees that that is the Campbell Ditch water rights. So when you read it and you put it in context and read all of the language together in a decree, when it says it is further adjudged that the Campbell Ditch is entitled to these springs, then the natural extension of that is that the Campbell Ditch water rights, which were previously decreed, have an entitlement to these springs.
To what from these springs? All the water at all times?
To satisfy, well, the water court ruled that the Campbell Ditch has the right to divert these springs up to 4.68 CFS total, and that's not being disputed. The fact that there is not a separate priority date or amounts is really irrelevant to this case, because the water court and all parties agree that there is not a separate decreed water right. If this was a separately decreed water right, then arguably you would have to have an additional amount, appropriation dates, those kinds of things. But that's never been Ring's position or the way it's been interpreted by the water court. The water court has said this is a decreed source of water. And the decreed source of water falls underneath, just like the Cherry Creek waters do. The springs fall underneath the same reading as you would interpret the way these water rights divert Cherry Creek.
Thank you.
I guess I'm a little confused then.
Yes, sir.
If you look at and good morning.
Good morning.
The first two talk about, I understand your point about said the Campbell ditch in we'll say the third paragraph that we're talking about.
Right.
The first two define Campbell ditch, but then it gives an appropriation date of 1883 and 1890 for the two water rights at issue. When you get to this third paragraph, there's no appropriation date listed for the water from the springs. Why doesn't that distinguish that third paragraph? I mean, your position is that this essentially is tied to the first two by nature of the word said the Campbell ditch, I assume. But the first two really talk about appropriation dates from Cherry Creek, waters of Cherry Creek, and then was it Devers Extension?
Correct.
So help me understand why those aren't distinct.
So the way the Ring has interpreted this decree is that we clearly have the Campbell Ditch water rights out of Cherry Creek. I mean, I don't think there's any dispute as to that. So then the question becomes, why isn't there a priority date for the springs? And the springs, as everybody agrees, aren't a separate water right. I think it's not the correct way to think about the way, when you read this decree in its entirety, the springs aren't a water right. The springs are an additional source of supply that satisfy the Campbell Ditch water right priorities. That's the way you read all of the language in harmony to construct this decree and give this language regarding the springs operation and legal meaning and effect.
So what gives us the appropriation date? I mean, I think your position, and I may not use the words correctly, forgive me, that the third paragraph kind of takes on the priorities of the first two. What says that? I mean, I understand your argument why, okay, this is a supplemental source, but I'm having trouble making the connection back to the other two, the priority dates of the other two.
I think when the court using the defined term, the Campbell Ditch, it was the intent, and we can go back and look at the extrinsic evidence too. If you look at the petition that was filed by Horton and Horton's attorney, in the statement, the intent is clear that they wanted 4.68 CFS with the source of that water being both Cherry Creek and the springs. So you can look at the extrinsic evidence if there's some question we need to interpret and supply some missing terms here, which the courts do. But if you're just looking at the plain language, the fact that we have this defined term, the Campbell Ditch, and you're correct in your assumption, is that the court was just merely saying you get 2.34 CFS under an 1883 priority, additional 2.34 CFS with an 1890 priority, all for the irrigation of 100 acres, with the source being both the Cherry Creek and the springs. And that's how when reading the decree and all of its components together is the interpretation that we're setting forth.
So last question. So how do you decide then whether it's the 1883 priority or 1890 priority?
So what happens is, let's say water in Cherry Creek is not fully satisfying the Campbell Ditch water right. It would just act as a supplemental supply to fill in whatever deficit is making, or whatever deficit the Campbell Ditch is not receiving out of Cherry Creek. That's how you would determine it. So if the 1889 water right is not in priority and the 1882 water right is in priority, then it would only satisfy up to the 2.34 CFS, at least in terms of administering these water rights within the priority system.
All right. Thank you very much.
Did you have a question?
He just asked it, so
You look like you were.
about to, but he got it. Thank you.
It's a mind meld thing.
Actually, I do. I think one thing that strikes me is that the reference to the springs, even assuming that, I understand your argument to be that the spring water is to be deemed a supplemental source, but I guess I'm wondering why then not incorporate reference to the spring water into the paragraphs? Why is it set off separately? I mean, it seems to be if it was going to be treated as a supplemental source, it would say, 2.34 CFS out of the waters of Cherry Creek and these springs.
I think the way, and extrinsic evidence, I think, helps explain this, is that when you see this, there was some evidence that these springs were never diverted before and were not part of any natural stream. This is what's said in the petition and the statement of claim by Horton. So I think there was some attempt to try and distinguish these springs as a separate source of water that aren't necessarily a part of the Cherry Creek system. So I think there was an attempt when the court said it is further adjudged that the Campbell Ditch is entitled to these springs. I think there's two things. One is making sure there wasn't a third water right, which has been argued previously, but it was also trying to make some distinction that these springs are a different source that are decreed to the Campbell Ditch priorities.
And can't we perhaps also then look at that same extrinsic evidence and say that really what was going on was Horton was trying to actually appropriate a separate right, but fell short? That statement of claim sought to actually separately appropriate water from these springs, but that's not what ended up being decreed.
No, the map and statement, so so there was several documents of extrinsic evidence here. The map and statement filed shows that there was some intent to have a third water right as part of the appropriation of the Campbell Ditch water rights. The map and statement also has several other inconsistencies. For example, there's two head gates, one being another head gate for the Devers extension, and there is no evidence in any of the record that was actually filed that indicates the second head gate was ever built. So yes, the map and statement does have some language and some indication that perhaps there was supposed to be a third water right here. But when you get into the statement of claim that was actually filed by Horton, in conjunction with the petition that was filed, the relief requested ultimately ended up being 4.68 CFS from both Cherry Creek and from the spring. So at some point between the filing of the map and statement and the petition and the statement of claim actually filed by Horton, there was some change in Horton's position to not have this adjudicated as a third separate water right. I mean, there's no other evidence to say why Horton did that. We don't have any other evidence other than the documents that have been presented to the court.
So what inferences then are we to draw between the 1905 decree and the 1909 decree? In the 1905 decree, there are these factual findings that suggest that there was an attempt to appropriate these waters from the springs, and that particular finding is absent in the 1909 decree.
Again, I think the 1905 decree at this point becomes additional extrinsic evidence that the court could rely upon. So there seems to be concern as to what is the appropriation date here. I think the importance of the 1905 decree is there's language that says these springs were constructed in 1903, and there's a lot more findings of fact in terms of how the appropriations were made and what occurred that aren't present in the 1909 decree. But the decretal language itself is virtually identical. I think there's a "the" missing out of the portion of what's going on with the springs themselves and what we're interpreting. And ultimately what we see is the same exact language, decretal language. And I think, remember, between that 1905 decree and the 1909 decree, that if there was meant to be this unenforceable entitlement, the court could have clarified that in the 1909 decree. Rather, it just decreed the exact same thing which was decreed in the 1905 decree. So that provides additional extrinsic evidence that, look, if you look at all the documents together and pile them up, Horton asked for 4.68 CFS from Cherry Creek and the Springs. The court decreed that in the 1905 decree and then just carried it over and decreed it in the 1909 decree. The other important thing with the 1909 decree is if you look at it, there's some recital language or findings of fact that the 1909 decree only changed the senior priority from 1882 to 1883. So that was the only thing that really was decided in terms of the 1909 decree. So we can assume that anything that happened in the 1905 decree in terms of the findings of facts, those facts didn't change as a result of entry of the 1909 decree.
And yet they were omitted. I mean, that's
Well, but
That's
here-
the head scratcher, right?
But here's another important fact, Your Honor, in comparing the 1905 and 1909 decree. Everybody here agrees that these springs are decreed to irrigate 100 acres that owned by Horton. Those were all findings of fact that were in the 1905 decree. That language, however, is missing from the 1909 decree. We don't now all of a sudden say, wait a minute, the 1909 decree is missing these findings of fact, and therefore there's this whole invalid appropriation, which is what is being argued or was found by the water court. Those findings of facts are still findings of fact, and they weren't overturned or changed as a result of the difference between the 1905 and the 1909 decree.
Thank you.
Let me jump in then and ask, I mean, why cannot we read this, and I think that I'm picking up on Justice Marcus's questions to you. There was an appropriation, but Horton failed in his effort to adjudicate this right. I mean, why can't we read both the 1905 and 1909 decrees to say that? In other words, it's not a failed appropriation. There was an appropriation, but you have whatever requirement you had to adjudicate, that's where Horton failed. And that would be supported by the language when, two paragraphs say ordered, adjudged, and decreed, and one paragraph says just adjudged.
My thought on that, Your Honor, would be twofold. One is, why say anything at all? If the point is that Horton failed in appropriating these springs, why not just be silent on it?
So, but I think there may be, I'm speculating at some level. I mean, there's an acknowledgement, there's an appropriation. So, you take water, but you can't enforce this against anybody else because you don't have a priority against anybody else.
Well, let's talk a minute about that priority, but let me answer let's talk a second about the priority. This priority date is a little bit of a red herring in going down a rabbit hole. Water rights, of course, and the court knows this, is appropriation dates are important. But more important to the terms of administration is the actual adjudication date of a decree. So here, when we apply this to the actual facts to this case, there's only really two parties that are claiming an interest to divert these springs. One are the Campbell Ditch owners' ring vis-a-vis the Campbell Ditch decree. The other one is the Dill Pierce parties who are parties here underneath their 13 appropriation. Regardless if there is an appropriation date, as between two priorities that were decreed or two adjudications, we know that a 1909 decree is senior or superior to a 2013 decree. So regardless if the appropriation date is 1903 or 1883 or 1882, we know that the adjudication of these springs took place in 1909, and that is a superior claim to anything that comes subsequent afterwards. So this fact that you have to have the exact priority is not relevant in terms of the administration of these water rights today because the 1909 decree is a superior and prior decree to anything that's happened after.
But you're assuming that the springs were adjudicated in 1909, and if I'm understanding your colleague's position, it's that they weren't. And that's why the 2000 whatever decree takes precedence. That's the first time the springs got adjudicated.
I would strongly argue that the word adjudged means adjudicate. I don't know how you say we adjudge that the Campbell Ditch is entitled to these springs is not an adjudication. That is the definition of a judge. So I think that to say that there's not an adjudication here when the plain language says it's adjudged is just not a correct position.
So then, and I'm sorry to take up so much of your time. Thanks for your patience. So what do we make of the fact that it doesn't say ordered, adjudged, and decreed? I mean, the court seems to have drawn a distinction between those words.
Again, I think it goes back to the incorporation. It was ordered and said and decreed to the Campbell Ditch. And it goes back to then is further adjudged to the Campbell Ditch, these springs as an additional source of supply.
Why not further ordered, adjudged, and decreed, if that's what the court intended?
I think the court's clear in using the term adjudged. And I think it goes back to that there was not a separately decreed water right. If the court had used that language, then there would be this argument that this is not a decreed source, but rather a separately decreed water right, which everybody has rejected at this point in time.
I understand. Thank you.
I believe I actually hit on most of my points. I just did want to save some time for rebuttal, but I did want to point out there was a SIR reply filed in this case. The SIR reply argued that Ring had inappropriately raised an argument in its reply brief. In its reply brief, Ring responded to an argument raised by the State and Division engineers that there had been past administration by the State and Division engineers that these springs had never been treated as an enforceable right underneath the Campbell Ditch. Ring raised this argument in its reply brief in response to the State Division engineer's brief that that's just not true. There had been instances where the division engineer has treated the springs as being part and parcel in a source of supply underneath the Campbell Ditch water rights. Chief Justice, I'd like to reserve the remaining time for, unless there's any questions, I'd like to reserve the remaining time for rebuttal.
Please do.
Good morning. May it please the court. My name is Sarah Klon. I'm here today on behalf of the appellees Don and Kathy Dill, who are joining me here in the courtroom, and Francis and Jerry Pierce, who probably are watching on the live video stream, which is slightly terrifying. Your Honors, this case is about spring water rights that were appropriated in 1903 and adjudicated in 2017 in case number 17SA331, one of the cases that is on appeal here today. And we'd ask that this court affirm the judgment of the Water Court on the interpretation of the 1909 decree. Before responding to Ring's legal arguments and some of the questions of the court, I want to just take one step back and set the context for why Dills and Pierces brought these two Water Court actions. The springs at issue in this matter were appropriated for use on my client's property. Aerial photos that are in the record indicate that they've been used to irrigate my client's property since at least the 50s. Pierces acquired their property in the 1980s, Dills in the early 2000s, and the springs were used by them and their predecessors up until 2011, when the division engineer curtailed the use of the springs. This caused all kinds of problems for Dills and Pierces, and they tried to negotiate a solution to the curtailment, and Division Engineer Whitty suggested that perhaps the best course would be to ask the Water Court for a declaration of the 1909 decree. So they filed case number 12CW95, the other case up here on appeal, and asked the Water Court to declare that the springs were separately adjudicated from the Campbell Ditch water rights. They also asked for a preliminary injunction ordering the division engineer to allow them to go back to diverting the springs. So the court held an injunction hearing. At the conclusion, Judge Swartz acknowledged the hardships suffered by Dills and Pierces from not having their irrigation water, but he determined he could not grant an injunction, and this is in his April 3rd, 2013 order in the record, primarily because the springs had not been decreed, so there was no enforceable water right to order the division engineer to deliver. In other words, not only were the springs not a separate adjudicated water right, which is what Dills and Pierces went into court asking for a finding of, they weren't adjudicated at all. Subsequently, Dills and Pierces filed 13CW3041. They claimed a flow rate of 3.12 CFS, which was subsequently reduced to 1 CFS based on engineering in that matter. They claimed an absolute amount of 0.46 CFS, the remainder conditional. They identified the lands upon which the water rights were going to be used and the uses to which they were going to be put. And after a one-day trial in 2017, the Water Court issued a decree adjudicating the springs to Dills and Pierces and finding that they were entitled to a decree consistent with all of the claims in their application. This is the first decree that adjudicated the water rights in the springs.
Counsel,
Yes.
what do you make of the word adjudged in the third paragraph of the 1909 order?
I think that adjudged is a way for a court to say, I'm finding this, I'm finding that. I don't think it's a magic word that gives any more or less meaning to what follows it in terms of giving content to that. So if you said, I judge that I have a parking ticket, well, maybe you do, but that doesn't necessarily mean as a matter of law anything. So I think you have to go to the next step and read the language of that portion of the 1909 decree. And as has been discussed already today, the language the right to receive and conduct the springs without a priority date, without an amount, without uses, is not adequate to adjudicate an enforceable water right. I do think it is, as one of the justices up here suggested, I do think it was an acknowledgement by the Fremont County District Court that Mr. Horton hadn't quite satisfied the burden of proof in order to show whatever the court was looking for in that 1909 decree.
And could I ask, so what's the significance of the judge judging that? What would be the difference if he didn't say that?
What is it, ask your question again, I'm sorry.
What's the significance of judging that the party has the right to receive and conduct water through the ditch? I take it that's what you're saying. What right does that entitle the party to that it would not otherwise have without that judging?
I suppose it puts the water officials on notice that the users of the water at that time could be receiving and conducting these springs as a source of water for the Campbell Ditch. It could put others on notice that this is a option that the Campbell Ditch owners have, but without the indicia, what I like to call the indicia of the water right, there's nothing for the water commissioner to administer. So it's notice as much as anything, I think. I don't think it's a...
And that's in effect, I take it you're saying it has no significance legally. It doesn't entitle
No
this party to
significance
anything
legally.
it couldn't do otherwise.
Correct. Yes. And it's this distinction between what's legally effective in that language versus the words and the attempt by Ring to make some kind of legally enforceable interest out of a combination of all the words in that decree, I think, and that's where their appeal fails. There needs to be an acknowledgement that you can appropriate a water right. This court has found this on many occasions. You appropriate a water right by diverting it to beneficial use, but you don't get an enforceable property interest until you satisfy the district court's requirements to adjudicate that right. I believe Ms. Schultz is going to talk about the specific requirements that courts were looking for in 1909, but there was quite a laundry list of things that the district court had to find in order to adjudicate a water right. And those are missing with regard to the springs.
What do you make of, oh, go ahead.
No, please.
The language, thank you, where it says, said the Campbell Ditch, clearly refers back to the prior two paragraphs, and it says entitled to receive. That seems to me, the court is, let's take your word, the court is making a finding of an entitlement. Why doesn't that support Mr. Showett's argument that these are tied to those priorities set forth in the prior two paragraphs?
Well, first of all, I think the idea that capitalizing the Campbell Ditch creates some meaning is a red herring, to use Mr. Showett's phrase. It's just the name of the ditch, so it was capitalized. If you look at the extrinsic evidence in the record, there's no evidence that the springs were appropriated in 1882 or in 1890, and we need something. If we're going to be inserting terms into the 1909 decree, we ought to be doing it by reference to historical documents. And I know this court has historically not wanted to insert terms into decrees, but I think that's what you have to do here in order to give the kind of effect that Mr. Showett's asking for to the Campbell Ditch. The map and statement suggest that the springs were appropriated in 1903. In fact, that's what the Water Court found in 13CW3041. That is our appropriation date. And contrary to Mr. Showett's argument, I think an appropriation date actually is pretty important. You can't have a priority date, an adjudication date, without having some evidence of appropriation. So I also think there's a kind of lurking in Mr. Showett's briefing is this idea that somehow this water is non-tributary. Somehow or other this water should be determined to be free from any prior call. It's in the brief that the reply brief, I believe. if there was going to be that kind of a finding, then I think that the court would have made a much clearer statement in the language that this water can be taken anytime, there is no priority date because there doesn't have to be a priority date. But in the absence of that, the default in this state is that all water's tributary. And if it's tributary, it's subject to appropriation. If it's subject to appropriation, then it's subject to the priority system and to curtailment. And we don't have the 1909 decree doesn't give us the mechanics in order to make that work.
Ms. Clown, good morning. What language would need to be added to that to make it a valid decree then? Or
I think you would need to have an appropriation date. You'd need to have an amount. You'd need to have lands to be served. You'd need to have the uses identified.
so basically all the same language that's up 2 paragraphs before.
But
Sorry. That would be true certainly if it were to be decreed as a separate water right. But is that true if it's simply being deemed a supplemental source for the 2.34 CFS and flowing into the Campbell Ditch?
I think if the supplemental source, if there was some evidence that the supplemental source had been appropriated as a source for the Campbell Ditch at the time of the appropriation, you might not need all of that. But there's no evidence of that. So whether we want to call it a separate water right that operates separate from the Campbell Ditch, or we want to talk about a supplemental source to serve the Campbell Ditch, either way, there needs to be the indicia of a water right in order for that supplemental source to serve the Campbell Ditch. One of the things when I took over this case I did was I went and looked to see, is there such a thing as a supplemental source? Does that operate differently from a decreed water right?
And
We
that's
weren't
my
able to
question.
find anything.
Yeah, and I
It-
wasn't either.
No, there isn't, we weren't able to find there's no separate animal called a supplemental source. Supplemental sources in decrees have priority dates, they have amounts, they have all the same things as separate water rights. Maybe they're not separate water rights because they have to be taken through a particular structure. So it's 2 or 3 sources that could go through a particular ditch, but they're all going to have those indicia of a adjudicated water right.
So as it's worded right now, could this be administered as supplemental source?
No.
And what about the argument that your opponent made a moment ago that you could just use the indicia that is included in the other 2 rights or in the 2 adjudicated rights? Why can't we just do that in administering the supplemental source?
That would require the court to imply the appropriation dates associated with the Devers Extension and the Campbell Ditch, the 1882 and 1890, or flip those around, 1890, 1882, or 1883. And it would require it to imply the other elements of a water right that were associated with the Campbell Ditch appropriation. The historical evidence, the extrinsic evidence in the record doesn't support that appropriation date. The only appropriation date the historical evidence supports is a 1903 date. As we said in our response brief, at times this court has been willing to imply certain limitations on a water right in order to make it work. But the times when this court has been willing to do that have been quite infrequent and typically have not resulted in making up a water right out of whole cloth, which is what I think would have to happen here.
And following up on that, is the fact that you have different priority dates for the 2 adjudicated rights, is that problematic with respect to the administration of the supplemental source?
Well, if you're going to imply the adjudication or the appropriation dates of the other 2 water rights onto the supplemental source, is that what you're asking?
Right.
I think that would be a problem, yeah, because you have to, what's the water commissioner supposed to do? Is he supposed to decide it's an 1883 today and an 1890 tomorrow?
Thank you.
May I just jump in for a second? I guess I still find myself stuck at that fork in the road on whether there is ambiguity in the first place. As opposing counsel pointed out, and as we've already discussed, a judge seems pretty unequivocal. I assume for the moment that I'm not finding the parking ticket analogy very persuasive. Help me get to ambiguity that's going to allow you to make what I acknowledge are some fairly persuasive extrinsic evidence arguments. So can you tell me more about why you think a judge to receive and conduct is not really unambiguous?
Because a judge to receive and conduct doesn't give the water commissioner enough information to do anything with
But
water
to
rights.
get to that conclusion, we need to go to the extrinsic evidence, don't we? Much of your argument rests on the statutory scheme at the time, which you acknowledge constitutes extrinsic evidence, right? So it sort of becomes, well, it's got to be, because otherwise it wouldn't be administrable.
Well, and maybe I'm not understanding your question, Justice Hood, but I think when I look at that language and think about being the water commissioner that has to decide whether to let the head gate up or down on a particular day, he doesn't know.
And so
So-
that is the answer, is it just can't work without it. Yeah. So it's got to be more, and therefore it is inherently ambiguous.
It's exactly what Judge Schwartz said. Judge Schwartz said in one of his orders, something was missing. Something was missing. It doesn't have all of the elements of an adjudicated water right, therefore it isn't an adjudicated water right.
Can I ask, sort of following up on something that Justice Hood just said, the briefs do seem to suggest that the statutory scheme at the time is extrinsic evidence. I guess I've not thought of law as being extrinsic evidence. How is the law extrinsic evidence?
Well, I would like to punt that to my colleague, Ms. Schultz, because I believe that was her argument. And I believe I've used more than my 15
Ms.
minutes.
Klein, can I ask you one final question? I know
course.
you want to get done, and this is a really basic question. If this isn't an adjudication of a water right, that last paragraph, what is it? Why is it there? What does it mean?
It's an acknowledgement, an acknowledgement that Horton failed to actually provide the facts necessary to create an adjudicated water right in the Springs. Why did the court put it there? We don't know. We know there was, and don't want to jump back into the extrinsic evidence issue with Justice Hood, but we know there was a hearing in 1908 because there was a problem with the 1905 decree. And I think that's maybe worth spending a second on at least. When you're interpreting the 1909 decree, it's important to remember the 1905 decree existed before. It had other information in it that's missing, and it was annulled. So whatever happened at that hearing, we don't have a transcript, we don't know. We can't really know exactly what happened there, except that the court found it important to include this. If Mr. Showett's interpretation of what happened at that hearing is correct, all that the court had to do is take that 1905 decree and interlineate the right priority dates for the Devers and the Campbell ditch. That's all the court had to do. We've seen courts do that before. He issued an entirely different order, and the order was missing significant pieces of information, and for whatever reason, perhaps because of the, keep jumping into the extrinsic evidence, Justice Hood, I'm sorry, but you know, it was quite a tangled property ownership related to the water right. I don't know if you've had a chance to look at any of those documents, but perhaps it was the district court holding out a thin straw for the trustee of the guardian of the youth who was then the owner of the Campbell Ditch water right, Horton's son, to try and come back and try again during the next supplemental adjudication.
All right, thank you.
I have one follow-up, I'm sorry. You mentioned a moment ago that you had gone back and looked to see if supplemental water is a different animal, and you said that you couldn't find anything like that. Same question with respect to what you just talked about, the last paragraph being simply an acknowledgement that Horton just didn't do enough to be able to have an adjudicated water right, a separate adjudicated water right with respect to the Springs water. Have you seen that anywhere else, or is that something that was typical at the time?
I haven't seen that anywhere else. I've seen other, what I would call unusual language in early 20th century decrees where the judge probably knew exactly what he was doing and the people in the room probably understood it, but in today's translating it 120 years later, we have a hard time figuring out what it was about. I'm not bothered by that. I think that the court did what it did. It wasn't too long after that that the statutes changed and there was an opportunity to appropriate a conditional water right, and that's effectively what we had. the owners of the Campbell Ditch in 1909 had effectively the 1909 equivalent of a conditional water right. If the court doesn't have any other questions, I'm going to turn it over to Ms. Schultz. Thank you.
Ms. Schultz, I'm going to dive right in, if I may.
Please, the court.
I'd like to pick up kind of where the conversation left off and ask for your insights into that final paragraph and what do you think it purports to accomplish?
I believe that the court did two things with that third paragraph. I believe first, the court acknowledged an appropriation that was not sufficient to be adjudicated with a priority. And I also believe that that paragraph indicated to the water administration, the water commissioner of the district, that water was allowed to flow into that extension and down to the head gate. And if not required by the priority system, there would have been nothing to stop the owners of the Campbell Ditch from using that water. I think that it's important to know some of the reality on the ground that we're talking about. The extension in 1903 was from the Campbell Ditch headgate on Cherry Creek across the creek and up a hillside at about 9,000 feet elevation for about a mile of length. This is not easy terrain. It's not, especially in 1903 and 1909, acknowledgement that somebody made the effort to go and dig a ditch on this hillside is an important acknowledgement, and also acknowledgement that administration could allow water to run in that ditch unless a court told the water commissioner otherwise is also fairly important. I have heard stories from the Dills that it can take nearly half a day to hike from the Campbell Ditch headgate to the extended ditch headgate at Old Horton Creek where it collects those spring waters. So I think it's important to remember the court was acknowledging reality. The reality is the ditch existed. The reality is water flowed in it. And I believe the court was telling the owners of the water rights and the water commissioner that water could flow into that ditch, but there's no enforceable priority to do so. If somebody else appropriated it, they would have a better right. Or if Mr. Horton or his grantees came back and proved that they had completed whatever was lacking at the time to adjudicate a complete water right, they could do so.
So do you agree with Ms. Klon that this was akin to a conditional right before such things existed in our statutes?
I think akin, except that conditional rights as we consider them now have a built-in ability to return and just say, I proved everything except for beneficial use, and so now I'm coming to prove beneficial use to you. I think this was not quite as complete as what we consider a conditional water right today, but at the time there wasn't really such a thing. And so I think akin, but loosely akin, if that makes sense. I don't want to say it was certainly a 1909 conditional water right because I don't believe that was completely well thought through in the statutes at the time.
Ms. Schultz, can I follow up on that? So basically, it's close but no cigar kind of a paragraph, right?
Correct.
If that's the case, why did the Horton lineage just shrug their shoulders and walk away then?
I don't know. You can see from the introductory paragraphs in the 1909 decree that Mr. Horton was no longer in the picture. There were multiple grantees. And my best guess, not having been around at the time, is that the property and the ownership had been split by Mr. Horton sometime between 1905 and 1909. And whatever happened there, there's two trustees named as the parties of interest. Whatever happened at the time, they simply didn't follow through. And it's not clear to me, I haven't investigated whether or not there, you can draw a straight line from Mr. Horton to the people named as the parties of interest in the 1909 decree, all the way down to who we have before you today.
Isn't another explanation, though, that they were using the water as a decree?
Sure. Another explanation is that they were using the water and that the water commissioner, in the absence of having a decreed right to the springs, allowed that to continue until there was evidence that the water commissioner needed to curtail the use because they believed there was some injury occurring as the result of undecreed use.
Is a statutory scheme, an old statutory scheme, extrinsic evidence? She punted to you, so now you've got the ball, you're ready to run.
She did punt to me, and I believe that I believe the intent of the General Assembly at the time behind the statutory scheme is extrinsic evidence. I believe the law itself is relevant information to understand, and I believe the law as it existed in 1908 is informative as to what the decree did provide.
But is it extrinsic evidence? I mean, could I, for example, say, I think the language in the decree is unambiguous, and part of the reason I think it's unambiguous is because the law in place at the time required certain things for a decreed water right, and they're not in there. Am I relying on extrinsic evidence for that?
I was going through my notes, and to be honest, I couldn't find the list of what the statute says is extrinsic evidence or what kinds of extrinsic evidence can be looked at in statutory interpretation, which is what we normally infer to decree interpretation in the absence of a case. I do not remember seeing a case that says absolutely the law in place at the time is extrinsic evidence. I think it's the next step. The intent of the General Assembly behind the statutes in place at the time is extrinsic evidence. I believe the law is the law, and today, if we are interpreting a decree that was issued 3 years ago, we're going to say the law is this, and so I believe you can rely on the law at the time without having to say that the decree is ambiguous in order to understand what that law was.
Okay.
I wanted to make one point that I think has been made, but I think is also really important. Ring argues in briefing in here today that the springs are a supplemental source of the 1883 and 1890 Cherry Creek priorities. These are Cherry Creek priorities number 3 and 4. And at the time that both of those priorities were initiated, and initiation under the statutes at the time started with construction of a ditch. At the time those two, the Campbell Ditch and its extension, were constructed, neither ditch felt the benefit of the springs flowing into Cherry Creek. And there is no evidence and no indication in the decree itself that the appropriator of the Campbell Ditch and the Devers extension intended in 1883 and in 1890 to go and get those springs. The law has always been in Colorado that a water right is limited by the intent of the appropriator at the time of appropriation. And because the original appropriator, there's no evidence that the original appropriator did intend to go and get the springs until 1903, which is 20 years after the 1883 appropriation, the court in 1909 could not have lawfully decreed such a right. The court could not have said that in 1909 that a part of an 1883 appropriation was a source that wasn't contemplated until 1903. Since we don't have any other indication in the decree or anywhere that this was the intent of the appropriator in 1883 and in 1890, we should not assume that the court intended to issue a decree in 1909 that was contrary to law. The springs simply could not have been a supplemental source to those early adjudications. One more point I wanted to make about the administration of water rights in 1909, the statutes at the time required that the court make findings, and in particular, those findings had to include a priority number and an amount. And the reason that the statutes required that is because when the decree entered, the court then directed its clerk to issue a certificate of the decreed water right. That certificate of the water right was given to the owner of the water right after they paid a fee. And the owner took that certificate and gave it to their local water commissioner, the water commissioner in the district. And the water commissioner used the certificate to write down the priority date and the priority of the water right and the amount of the water right. And that certificate is what gave the water commissioner the authority to regulate the flows of water into the ditch in the amounts and in the order of priority indicated in the certificate. Without that certificate, the water commissioner did not have the authority to regulate water so that it flowed into the structure in any particular amount. And the 1909 decree did not have that information for the springs. The engineers respectfully request that this court affirm the water court's interpretation of the 1909 decree. If you have no further questions, I will sit down. Thank you.
Counsel, may I ask, just before you get started, could you respond to the last point made by the state's attorney?
And what point specifically, Your Honor, just so I know?
That the 1903, that the springs couldn't have been a supplemental source to an 1890 and 1883 water right because there was no effort to construct that at the time.
The only way you come to that conclusion is by looking at the extrinsic evidence that was associated with this. If you look at the decree, the unambiguous language of the decree, again, it's Ring's position that these springs are decreed to those priorities. So if you're going to make this argument that the ditch wasn't constructed in 1903 or wasn't around in 1883, you only come to that conclusion by looking at the extrinsic evidence. And again, as I've argued before, is you have to look at, if you're going to look at the extrinsic evidence, you have to look at it in the totality. And what was ultimately requested and what was noticed by Horton was what was requested was 4.68 CFS from the springs and from Cherry Creek. So you have to look at that in totality. Now, if you're going to read in and imply terms, certainly you can use the extrinsic evidences to say you have to have a priority date. Then there's an argument to say, okay, well, perhaps we assign it a 1903 priority date so we can give this language meaning in effect. I don't think you have to. I offer that as an alternative.
Can I, you said that what was decreed was 4.68 from the springs and from Cherry Creek, but in the decree, it actually says, each of them says, out of the waters of Cherry Creek,
Correct.
the particular amount.
Correct. I agree. And then when you go look at the springs portion, the springs say, and all springs. I mean, there's this question as to what's the amount. It says all springs, everything that's entitled, everything along the line of the ditch thereof. The Campbell ditch is entitled to divert them. I mean, it says all springs.
Okay.
Mr. Schott, I'm afraid I'm not understanding the answer to Justice Hart's question. So let's assume, I'm not sure if you're disagreeing that we couldn't have a supplemental source for the 1883, 1890 decree because it didn't exist yet, there was no intent. And I think you said, okay, that's extrinsic evidence, and I guess my response is, okay, so it's extrinsic evidence. Wouldn't that explain why the court in 1909 did what it did? That Mr. Horton didn't prove up what he needed to do. I can't assign it back to 1883 and 1890 because it didn't exist.
And this question was asked earlier. I think if there wasn't an adjudication, why use the word a judge? I mean that's the heart of it. Why say anything? The court could have said nothing. Or it could have said exactly that. Horton has come to this court trying to adjudicate springs, but we feel like there's something missing, or he has not completed the appropriation, or he hasn't constructed the ditch. And the court could have said that. Courts do that all the time, saying, this applicant has not met his burden of proof in regards to this claim, and could have simply stated that. That's
So-
not what the court said.
But I think coming back to a question that Justice Gabriel asked earlier, there is this distinction between that third paragraph, which, so the statute in effect at the time talked about a petition to adjudicate. So there was a petition to adjudicate, and then about the entry of a decree. And the first two paragraphs are preceded by a statement of adjudged, ordered, and decreed. But this last one doesn't use the word decreed. Why not?
It goes back to the fact that there's not a separately decreed water right. And this goes back to Justice Hood's. The state is using the statute as extrinsic evidence to explain out why there's not a right to this. Because again, for a water right to exist, compliance with the statute may be necessary. But using that, they're trying to argue that there wasn't a water right associated with these springs. No one's arguing, Ring's not stating that there is a separate water right, and everyone's agreed to that. So to use the statute to say you need these things for a water rights, when that's not the position being put forth by Ring. Ring is saying this is a source of water, decreed to the Campbell Ditch, is using extrinsic evidence to try and explain away why this shouldn't be administered. And I want to point out that the division engineer, their position, what they stated was, this language was telling the water commissioner to allow for the diversion of this water. I mean, that's an adjudicated water right. I don't know what else is an adjudicated water right when they're admitting that the whole purpose of this language, at least underneath their interpretation, was to allow water to flow into the decree and allow the appropriators to take it. That's an adjudication.
Well, I think they're saying quite the opposite. They're acknowledging that it was happening, and they're saying there is no priority right here, so they have no right against anybody else who's in priority.
Then why not state that? I mean, it would have been very
Could have
simple.
said that, or they could have left it out,
They
and
could
we
have
don't know. Maybe it was, this is notice, as they say, and that was it.
But again, I mean, we have well-established black letter law interpretation of decrees. You read decrees within their plain meaning. You read all the provisions of a decree in harmony. And the goal of reading decrees is to make sure it's effective and operative. And to have this, to read in now to say the intent was to have an unenforceable water right renders the decree completely meaningless. There is no legal operation, and it's not reading the decree in its entirety in harmony with all the provisions, at least the decretal provisions of that 1909 decree.
Guess we've seen that before. We call it dicta, and maybe that's all it was. I mean, I'm being half facetious. I mean, maybe it's just dicta. And coming back to the questions Justice Hart and Justice Hood were asking you, I mean, can we not, in terms of looking at the face of the decree, make a determination that the decree can't say what you're arguing because it would be illegal? I mean, that's not extrinsic evidence if we say we have to read something on its face to comply with the law. And as I understood the engineer's argument, it wouldn't comply with the law because you cannot say, get an appropriation date back to 83 and 90 on the springs.
That's simply just not true that it's illegal. And the reason is we have what's called the relation back doctrine. And so actions that occurred before can relate back to the appropriation of other water.
But you have to have the intent, as they say, of the appropriator.
And no one has offered any, so the intent is if you look at the extrinsic evidence, there's evidence that the ditch wasn't constructed until 1903. But that doesn't go to the intent of the appropriator. As Ms. Schultz alluded, these are high up. Perhaps there was actions or surveying work or something else that perhaps was before the court that we don't have that occurred during this time period. Surveying, noticing, I mean, we don't know. But that's what the court, that's what was ultimately requested and put forth to the district court in 1905 in their petition to adjudicate these. And that's what ultimately was decreed by the district court.
You've talked a lot about the word adjudged. If the court at the time had said it is further ordered, would that be different?
I don't think so. I think, and this goes back to whether or not adjudged is dicta. I've never, if I'm ordered and adjudge something, I look at that as pretty strong language from a court that this is the order of the court. So I think adjudged and ordered could be probably used interchange it. You know, you can interchange those words. But again, the heart of this is whether or not a water right was adjudicated, and certainly a judge does reflect this concept and the notion that there wasn't a water right adjudicated, but there was an adjudication of this as an additional source and supply to satisfy the Campbell Ditch water rights.
So then what's the difference between adjudged and decreed?
I think they can be used interchangeable. I mean,
Really?
I think they could. I mean, a judge, well, perhaps a judge is more of a finding of what the court is applying to the facts, whereas decree is, and here's the order. I mean, I don't know if there's a huge distinction, at least in my mind, between adjudged and decreed. I want to point out, too, that an interpretation here, or at least Ring's interpretation, doesn't read in language. I mean, there is nothing in the 1909 decree that says it's unenforceable. You have to sort of read that into the decree to come to that conclusion. You also have to read out this language, this adjudged entitlement to receive and conduct these springs, to come to the conclusion that nothing was granted. Ring's position is the only position that sets forth an interpretation that complies with the plain meaning of the language, doesn't read in language, and doesn't read out language of the 1909 decree. For those reasons, we'd ask this court to overturn the water court and find that the Campbell Ditch water rights have an enforceable entitlement to the springs as a supplemental source and supply. Unless there's any questions, I have nothing further, Your Honor.
Thank you. Appreciate the arguments of both counsel. The case will stand submitted, and the court's going to be in recess for about 10 minutes. Please be seated. The next case on our docket is styled Arapahoe County Department of Human Services versus the people in the interest of DZB. We've amended this a little bit and scheduled this for a 40-minute argument. That'll be 20 minutes per side. And it looks to me like we've issued an order allowing the petitioner's side to split time as they see fit. Whenever you're ready, counsel, petitioners may begin.
Good morning. May it please the court. My name is Michael Valentine, attorney registration 34044. I am the Deputy County Attorney for Arapahoe County, and I'm honored to be here today on behalf of the petitioner, the Arapahoe County Department of Human Services. The issue in this case is whether the Court of Appeals erred in concluding that the non-party Arapahoe County Department of Human Services lacks standing to appeal a delinquency court's order for pre-adjudication placement. Petitioner respectfully argues that the Court of Appeals did err because it failed to apply the correct test for non-party standing in the Court of Appeals. Until the Court of Appeals decision, the well-established test for a non-party to establish standing to appeal a lower court's order was whether the non-party was substantially aggrieved by the lower court's order. And by substantially aggrieved, it refers to the imposition of some burden or obligation placed on the non-party that was not present prior to the court's order.
Mr. Valentine, let me jump in because your time is so short. What do you do about CWB? We appeared just last year to have applied what you would call the standing to sue test. We mentioned the substantially aggrieved test. I mean, how do those jibe with what you're arguing? And what's the distinction between substantially aggrieved and injury, in fact, to a protected legal interest?
First, I'll touch on CWB. CWB is different from our case in a number of ways. First, CWB addressed a foster parent's right to file an appeal on a termination of parental rights in a dependency and neglect case, which is under Title 19, Article 3. We are under Title 2 here. The foster parent also had a statutory right under 19.3.507 to intervene as a party in that case. This court correctly applied the party standing test in that case, found that the foster parent must prove an injury in fact to a legally protected interest to be able to take action and appeal that termination court order. In that case, the court, I'm sorry.
No, go ahead.
In that case, the court found simply there was no legally protected interest. In fact, the foster parent could not put forth the best interest of the child and could not stand in for the best interest of the child, which was represented by the guardian ad litem. This case is a non-party. The Department of Human Services has no statutory ability under 19.2 to intervene or become a party in the DA's filing of their delinquency case anywhere in statute.
All right, so a party standing to sue, we would look to the traditional injury in fact protected legal interest standard, but a non-party standing to file an appeal. Wait, I said this wrong. When we're dealing with a party's right to appeal, we look at the traditional standing test, injury in fact, legally protective interest. Non-party standing to appeal, we look at substantially aggrieved. That's your argument?
Correct. And by aggrieved, we mean any burden or obligation that was placed on that non-party that had nothing to do with that case prior to the court's order upon it.
Thank you.
The substantial grievance test is a Supreme Court test. The substantial grievance test has been vetted and applied since 1909 by this court in Wilson versus Board of Regents, and was correctly applied by our Colorado Court of Appeals in 1995 in the only other published Court of Appeals opinion in this state that deals directly with the Department of Human Services appealing a delinquency court's order granting it custody of a juvenile. However, under this Court of Appeals opinion, the Court of Appeals found as the basis for instituting this new three-pronged test upon a non-party was that by the Arapahoe County Department of Human Services simply asking for judicial review from the Court of Appeals on a delinquency court's order granting it custody, it was in fact bringing a claim under the statute and was therefore required to meet the party standing that Justice Gabriel asked the question about, a legally protected interest, or I'm sorry, an injury in fact to a legally protected interest. The flaw with applying injury in fact to a non-party is that the injury analysis itself refers to the injury that brought about the case, not the injury that it substantially aggrieved a non-party during the pendency of this case. So the Department of Human Services would have to prove an injury caused by the facts that brought about the delinquent case, not the court's order during DZB's delinquency case. Second,
Mr. Valentine, good morning.
Morning.
Sorry to interrupt you. My question was going to be with respect to what you just talked about. Isn't the injury in fact, when you're talking about an appeal or standing to appeal, doesn't that relate to the injury that may have been caused by the judgment or the order of the trial court?
It's petitioner's argument that that was another flaw of the Court of Appeals' opinion here. The Court of Appeals made injury in fact analogous to substantially aggrieved, which are two different legal and factual applications to a legal case, especially when it's a party bringing a lawsuit versus a non-party that had nothing to do with the case prior. I'll also point out that the Court of Appeals, even with that, never did an analysis of whether even an injury in fact substantially aggrieved the department. In fact, the Court of Appeals, in perhaps its most erroneous finding in this Court of Appeals opinion, found that any court order, any delinquency court order, or any injury was merely incidental to the department's general duties under Titles 19 and 26, and cited Titles 19 and 26 in their entirety as a basis for holding such order being merely incidental.
But what's the difference between an injury caused by the judgment or order versus being aggrieved by the judgment or order?
Two separate legal analyses. An injury in fact for someone to bring a lawsuit has to be by a party, and they have to be injured in fact by another person to bring an action against them. And it has to be a legally protected interest, of course, is the second. A non-party in the analysis merely has to be substantially aggrieved by a case that they had nothing to do with prior. So it looks to the court order. So substantially aggrieved looks, what was the impact of the court order during that active litigation? An injury looks at what were the injuries that brought up the facts of the case that brought about the lawsuit.
So that's true as the standards are typically applied, but is there a difference? I think this gets back to a question Justice Gabriel asked earlier. Is there a substantive difference between showing an injury and showing that you were substantially aggrieved?
I believe so, Justice Hart. That's a good question. I think that injury in fact, that the two different analyses make them, there's an inability to make them analogous, because an injury in fact to bring about a lawsuit, or even practically speaking, may not be incidental to the person claiming the injury. On the other hand, a substantial grievance, well, a grievance must be substantial, which is what was held in the 1909 Wilson versus Board of Regents. It has to be substantial to the non-party. So I do not believe they are equal.
But you're comparing, I think, the difference between standing to bring a lawsuit and standing to appeal. I guess my question is, if we're applying the injury in fact question with respect to the right to appeal, what's the difference between a showing that you were injured or that you have a legally protected right that was injured by the judgment versus showing that you were aggrieved by the judgment? In both cases, we're referring to the judgment. What do you see as the difference between those two?
I think one takes a higher standard. I think one takes a higher showing. I think that it is less of a showing. A substantial grievance, by definition, is some burden or obligation that brought the non-party under the court's jurisdiction. An injury in fact, I think, to bring a lawsuit is a higher standard. I think that we protect non-parties that are going to be put under the jurisdiction of the court and under the possibility of contempt of court that had nothing to do with that litigation in the first place. For example, the Department of Human Services. We mentioned in the previous case, an Article 3 case, that is brought by the Department of Human Services through the people of the state of Colorado. That is their general duties. They are not the prosecutor in those cases, but they represent the county. In these Title II case, or Article 2 cases, the district attorney brought the case. The department had nothing to do with the bringing. They were ordered into a case they had nothing to do with bringing.
Let me jump in, and I'm sorry we're using so much of your time. I understand what you're saying substantial grievance is a lesser standard, but as you just defined it, you said some burden or obligation that brought the non-party under the court's jurisdiction. Well, that would be a grievance if there was some obligation. What makes it substantial? How do we define that?
I would again point back to even the earliest cases in 1909. I believe it was Justice Bailey that issued the opinion that said you cannot appeal cases as a non-party to merely delay a case. Or in that case, it was to hold on to a valuable piece of property as the executor in a will so it didn't go to the University of Colorado Board of Regents. So the justice found that for mere delay or for other purposes other than a legally real grievance to them, I think that those were looked at as not valuable reasons to delay cases or bring frivolous appeals.
So let me ask it this way. If and I think your colleague across the aisle there, his argument in part is that the department was legally obligated to take this juvenile pre-adjudication. If there's a legal obligation, is the department substantially aggrieved? Or is it enough to say, I get to argue that it wasn't a legal obligation? End of story.
I think that to bring an appeal, you would believe that there was something done erroneous or an abuse of discretion was committed. However, the department does not have a general duty to take custody of children and act in the role of a parent and participate in a court case that it had no interest in prior just because of the filing of the delinquency case. I would also argue
But
that
there are statutes that allow the court to send a juvenile to one of your facilities pre-adjudication.
that is correct. Not in a vacuum, however.
Okay.
The court cannot do that without going through the safeguards that are in the statute under 19.2. I would also argue that why should we look at the removal of a child from a parent's custody and placement into the government's custody pre-adjudication is any less important or more important than post-adjudication under 19.2.907, where there are the safeguards for giving great weight to the people writing the social risk studies and things like that. I'd like to talk about why this case is so important. Just in Arapahoe County, the Department of Human Services is ordered into approximately a third of the 1,000 delinquency cases that are filed in our county alone. Of those cases that we are involved in, we are ordered to take custody and place the juvenile approximately 70 to 80% of the time just in those cases. So after DZB was published, what is the legal remedy or mechanism for judicial review to possibly cure an order having substantial impact on the county department or even direct impact on and harm on the juvenile, which is likely long-term placement and an inappropriate level of placement in congregate care?
And actually, to that point, if I could jump in, I recognize that several threshold arguments were thrown out, including mootness and final appealability of this order. And I'd like you to perhaps answer the question, why is this actually a final appealable order that ought to go to the Court of Appeals?
I can touch on both of those. As to mootness, I think it's simple. I think that it's capable of repetition whilst avoiding judicial review. I think it's of utmost public importance when we're talking about the removal of children from their parents and into the government's custody. I think there's a possibility of a reoccurrence of violation of constitutional rights that could happen without judicial review. As to the finality rule, I could argue, as was argued in CAG, that it was a final order upon the department the moment custody was granted. However, more importantly is that the Court of Appeals did not address finality. The Court of Appeals accepted the case. The Court of Appeals ruled just addressed standing, did not get to finality, never got to the merits of the case. Addressed standing to start. And in our opinion, misapplied the law, created bad law, that makes it virtually impossible for a Department of Human Services anywhere in the state to ever appeal a delinquency court order and publish the opinion.
Let's say we agree with you on that. My concern is, why is this a final appealable order? I mean, perhaps the appeal should have been dismissed on that ground, and help me understand why it shouldn't have been.
Hypothetically, if the Court of Appeals would have addressed finality and dismissed it, we would not be here today. But I do believe, as the Supreme Court's substantial grievance test has been applied, even to the Department of Human Services in 1995 in CAG, the Court of Appeals found that the temporary custody order removing a child from the parents and placing with the custody, government's custody, was a final order as to that non-party.
Mr. Valentine, on pages 4 to 5 of the reply brief, it says that the department is not asking us to determine either the merits of DZB's pre-adjudication placement order or even whether the department had standing to seek review of that order, and that instead you just are asking that we correct the erroneous legal standards, what you believe are erroneous legal standards applied by the Court of Appeals. That sounds to me like a concession that you did not have standing to seek review of the order from the trial court. Is that right?
It is not, Justice Samore. We do believe we had stand, but the problem is, the reason that's in our reply brief is because the Court of Appeals never got to the merit. The Court of Appeals never addressed finality of the order. The Court of Appeals addressed standing and did it in a way that precludes the department from virtually ever filing an appeal if it feels that an order has been issued on it, binding it to some obligation, and not having to appeal. So my quick answer to that is because the Court of Appeals did not address it. If we would have addressed the merits and brought the appeal here on those issues, we would be arguing the statutes and the Children's Code. But the standing issue is the only issue that we're here, the only issue that was certified by this court, and the only issue that I think we can address to reject the new three-part test for non-party standing analysis and reinstate the over a century-old substantial grievance test that is this Supreme Court's test. If there's no other questions, given the time, I would like to, first of all, reserve any time that may be still available after the Attorney General's argument.
May it please the court. My name is Sarah Richardson, attorney registration number 50946, representing the State Department of Human Services as amicus for the petitioner. The three-part test combining a plaintiff's standing to bring suit with a non-party standing articulated by the Division of the Court of Appeals is contrary to this court's established precedent. It is unnecessarily complicated, and it has wide-reaching effects that are deeply problematic for non-party state agencies. State agencies provide service to the public pursuant to broad statutory mandates, and when ordered to do so by the court, are almost always a non-party. They can be ordered to provide behavioral health services, juvenile delinquency and dependency services, services to the intellectually or developmentally disabled, or substance abuse treatment services, for example. In the case where a court may order a juvenile delinquent committed to the Division of Youth Services as a non-party agency, the division must consider things like gang affiliation, separating sexual offenders from likely victims, the mental health treatment available, as well as bed space and staffing in determining the facility in which to place a youth. If a judge were to order a youth placed in a particular facility, contrary to the determination of the Division of Youth Services, under the analysis of the Court of Appeals, because there's a statutory mandate to provide these services, no order would constitute injury in fact. Aside from the factual circumstances which make that order inappropriate, it would be a violation of the separation of powers under McDonnell versus Juvenile Court and Court versus Huffnagel. But the Division of Youth Services would not be able to show that the injury was to a claim under a statute, and it would not meet the legally protected interest prong. So the division would never meet the substantially aggrieved test. Even if it did, the Court of Appeals version of the test raises the bar from a burden, as it was in Colorado Permanente, to demonstrating an onerous and unique burden. So if the department believed that the judge's decision was unethical, illegal, or contrary to separation of powers, they would not be able to have the decision reviewed under the three-part test. Similarly, a court may order a defendant who appears incompetent to proceed to the Colorado Mental Health Institute at Pueblo. The Mental Health Institute provides, among other things, inpatient or outpatient competency evaluations. And a court may order a defendant to inpatient evaluation if the defendant meets one of 5 conditions. But a court order that interferes with the treatment decisions once in the custody of the mental health institution is a violation of separation of powers under Court versus Huffnagel. However, under the analysis of the 3-part test, the Mental Health Institute would be unable to show injury in fact because of their statutory duty to provide competency evaluations and treatment.
Counsel, what test would you have us apply for substantially aggrieved?
The substantially aggrieved test has been consistently applied to be either denial of a claim of right or, as applied to most non-party state agencies, it would be a burden or an obligation placed upon the agency. The separation of powers doctrine is important because it does not allow a judge to substitute its judgment for that of experts within the field, interfering with the executive branch performing its statutory duties. But although it would be substantially aggrieved, the Mental Health Institute would never be able to reach that prong if there was an unethical or illegal order. Regardless of the merits of this current case, the 3-part test should be rejected, and the substantially aggrieved test that has been consistently applied for over 100 years, most recently in Colorado Permanente, should be affirmed. Thank you.
Thank you.
Ryan Hardman, registration number 37922. May it please the court? This court should dismiss this case as improvidently granted. The issue that this court granted cert on was whether the Court of Appeals erred in concluding that the department does not have standing to appeal a juvenile court's decision concerning pre-adjudication placement. But it's unclear what the department is asking this court to do or what the department wants at this point. The department keeps changing its claimed injury. It seems to claim that it's injured by the generalized cost of having to place DB. For the first time in its opening brief in this court, it claims that it's injured by some courts, and I'm not even sure which courts, failure to follow the procedures of 19.115. And as Justice Samore pointed out, in its reply brief, the department says it doesn't even want this court to decide if it has standing. So I'm unclear what we're doing here. Second, the court's order was not a final appealable order under CAR 1, which is necessary even for standing, and which this court could decide because it's a jurisdictional issue. The order was a temporary order subject to further review. And in fact, the court did eventually sentence DB to the place where he was put pending adjudication.
Sergeant, can I jump in here?
Yes.
Good morning.
Hi.
Kind of harkening back to my days doing juvenile, there were times when I had requests to place delinquent kids in very expensive private hospitals, claiming it was best interest, where they could be upwards of $20,000 a month for this type of treatment. What does the department do if there's an order, if as a trial court judge said, yeah, I'm going to order that he be placed in the clinic in Kansas City, and I don't care what the cost is. What does the department do with that?
I don't know that the court could order specific placement. The court here just ordered that he
Well,
be placed
let's
in a
assume-
residential treatment.
But then, I mean, let's say I can't do that, right?
Okay.
Even taking your argument, then how does the department appeal that if you say you can't do that?
Right. The department could show an injury by showing it's something other than its just generalized cost. And here, the department didn't provide any record of what the cost of placing DB would be or why it was unusual. It provided no record about who was paying, about whether DB cost more than,
any other child.
But can I interrupt?
The department provided simply no record of that, Justice Boatwright.
Can I ask, though, so it seems to me that is what the department would do under the substantially grieved test. But if the test that the Court of Appeals applied is the correct test, could the department even get into an appellate court? Because what would be the legally protected interest that they would show?
I think in the district court, it could have shown that there were unusual costs. They didn't. And they provided no record to the Court of Appeals to show that substantial grievance.
But right, so you're arguing that the substantial grievance test is the test that should be applied, not the sort of, let's call it the three-part test that the Court of Appeals applied.
I think, just like this court did in CWB, the test could be whether a person or entity has suffered an injury in fact, and in the context of this case, the non-party standing to appeal, a substantial grievance, which, all of your questions were, what's the difference between a substantial grievance and an injury in fact? I think the substantial grievance subsumes an injury in fact.
But does it do that?
A legally protected interest.
But does it do that? I mean, our cases, I think, as your colleagues across the aisle said, do talk about denial of a claim or of right or imposition of a burden or obligation. That strikes me as very different than injury in fact to a protected legal interest. And you started by asking somewhat rhetorically, what are we doing here? I think they're asking us to say the Court of Appeals applied the wrong standard. It's not this injury in fact protected interest and substantial aggrievement. It is substantially aggrieved, and try again, Court of Appeals, remand. I think that's what they're asking for.
I think that the substantial grievance test, that they would have to show the imposition of a substantial burden or obligation.
Can you cite me a case where we said that? I mean, there's a whole bunch of cases that talk about the imposition of a burden or obligation. I don't remember one that said substantial burden or obligation.
This court uses the language a substantial or substantially aggrieved, and so this court does repeatedly use the word substantially.
But then we defined it as burden or obligation, and I asked your colleagues the same question, what does substantial mean? But it does seem to me our case law defines substantially aggrieved to mean the imposition of a burden or obligation.
And a direct one, as opposed to an indirect one.
Correct.
An indirect substantial, I would say substantial burden, and it's not in this court's opinion, it's in a Court of Appeals opinion called In Re JL, and the site for that is 112 P3rd 315, where the Court of Appeals has used the language a substantial obligation. So a non-party must have been denied some claim of right or be burdened with a substantial obligation.
It seems to me that certainly the amicus briefs in this case and the position of the Arapahoe Department of Youth Services hasn't foreclosed the possibility that what ought to happen here is that we ought to remand it to the Court of Appeals to apply the substantially aggrieved standard. It could very well be that the court would come out the same way and say there was no substantial grievance, but that the problem that counsel for the petitioner sees is that there's a Court of Appeals opinion sitting out there that applies a standard that would impact other counties and state services as well, and that's what they're looking for, is to correct that problem.
It's true that the department fails any test that you adopt. But I would say, or I do say, that this court applied the same test recently in CWB, and that it's not an incorrect test.
But isn't there a distinction, as counsel, I think it was Mr. Valentine raised, CWB dealt with a party. They had intervened below. They were a party. We have a non-party here. Isn't that a distinction?
As I read CWB, and my experience with termination proceedings is basically limited to reading CWB, but this court found that the foster parents, I think, as I read it, this court treated the foster parents as a non-party to the appeal. And they said that the foster parents only had procedural rights and not substantive rights in the outcome of the appeal. And so this court said that the foster parents had not shown a substantial grievance related to a legally protected interest. And so just like the Court of Appeals did in DZB, instead of injury in fact, It applied the higher substantial grievance test, which would include an injury in fact, to a legally protected interest. So I don't think that the Court of Appeals confused the test. It applied the same test as in CWB, but whatever test that we apply, the department fails. And if this court, or if the department isn't asking this court to decide whether it had standing, it feels to me like they're just asking for an advisory opinion, that they're not asking you to decide this case, which is not this court's job.
Can I take you back to, you earlier stated that your position is this was not a final appealable order.
Right.
And yet you're also saying that in some circumstances there would be standing to appeal such an order. So I'm trying to reconcile those two positions.
For an interlocutory appeal, I'm not sure that a different standard would apply. But if they need to, for example, in a Rule 21 proceeding, I'm not sure if the test for standing is different. But I do think it would be an interlocutory appeal. This is not a final appealable order for a direct appeal as it is postured currently.
So to the extent you're talking about standing, you're assuming that that would be standing in the context of a Rule 21 proceeding or a 106 action or something like that. Okay.
The department doesn't have standing because it hasn't shown a substantial grievance. In fact, the department concedes that a court can place a juvenile pre-adjudication in its custody if it doesn't object. The department is simply unhappy or disagrees with the court's exercise of discretion in this case. And as that concession shows, the costs of placing DZB were ordinary expenses spent to fulfill their statutory function of caring for children placed in their custody pre-adjudication. This court's opinion in Padilla-Lopez supports that decision, or supports that conclusion. In that case, this court found that the department was not aggrieved by having to spend money to fulfill their public function of caring for children in dependency and neglect cases. And so.
But doesn't the department get to come and argue, I'm just playing devil's advocate here with you, why don't they get to come argue that the court did not have the legal authority to place the child as it did? I mean, you would foreclose them from ever making that argument. Your reading of the statute is what it is, and you may be right. But why don't they get to say, we are aggrieved, there is a burden on us. We are now in a situation of parens patriae. We don't think the court had a legal obligation. We want to appeal that. Why would we foreclose that?
First of all, I think they could if they established an injury and it were through the right avenue.
But you're requiring them to prove the merits before they have standing. That's my concern.
First of all, it would be a proper interlocutory appeal. The temporary order in this case is not a final appeal.
Sure, let's assume it's final for purposes of my question.
But the department's duty to care for children and the court's authority to place children are different questions that are governed by different statutes. And they're made fuzzy in this context by their very generalized claimed injury of just general costs, which they haven't even shown what those costs are. And so those two questions, the line between them becomes fuzzy, but they are two separate questions governed by different statutes.
Sure, and I agree. It seems like the injury has moved around a little bit. I'll agree with that. But I think they ultimately landed on the court didn't have authority to do this. And you would say they have to prove that before they have standing, and I guess I'm wondering why. Why can they not say, we have a legitimate grievance, you've put a burden on us, we don't think that the court had authority, we'd like to appeal that?
The court's authority was the merits of their appeal. And I argued that they didn't have standing because all that the court ordered them to do, when they claim that their only injury is placement costs, they didn't show that it was anything above their requirements under the statute to care for DB. And maybe it is a proper interlocutory appeal, perhaps.
Let me give you a hypothetical, because your time is short. I know your understanding is that they're viewing it just cost. Change the facts. The hypothetical is their position is the court lacked the legal authority to order us to take this child. Do they have to prove that the court did not have legal authority before they have standing, or can they just say, the court's imposed a burden, we don't think the court had the right, we can appeal?
No, they have to show a substantial burden, and they have to provide some record of what the cost even is. Here, we don't even
You're going
know-
back to cost. Take cost out of it. I'm talking about a legal obligation. Their position on my hypothetical is the court had no legal authority to order us to take this child, period. No legal authority. Why do they not get to file an appeal to make that argument? You, I think, are saying they have to prove that before they have standing. And my question is, why is it not enough for them to make the argument and then they have standing?
They did, that was the basis of their appeal, but they didn't have standing. But to appeal, you have to show that you have standing. And here they did not show that they had standing, because you have to show that you were substantially aggrieved, and they didn't show that.
So on my hypothetical, they do have to prove that the court had no legal authority.
No, the court's authority, separate issue, separate statutes, separate question. Whether they were substantially aggrieved, you look at the statutes explaining what their duty is to care for children pre-adjudication. And they are different statutes. The statutes that require them to take children pre-adjudication would be 19.2.4021A, 19.2.310, and 19.2.202 to begin with. But they don't have to prove authority to prove that they were injured.
Thank you.
This court should dismiss as improvidently granted. But if this court does not, this court should affirm the Court of Appeals decision dismissing the appeal, because the department has not proven that it was substantially aggrieved. The Court of Appeals did not confuse the tests in this case. And the Court of Appeals decision was not overbroad. It was limited to this skeletal record and these circumstances where the department's only claimed injury was generalized costs. If the department shows a different injury in a different case, including even irregular costs perhaps, they could potentially establish standing in a different case. They simply did not do so here. And for these reasons, I respectfully request that this court affirm the Court of Appeals decision dismissing the appeal. Thank you.
Thank you. We've used up all the time. Appreciate the arguments of both counsel. The case will stand submitted, and we're going to move right on to our next case, People v. Wood. Both counsels situated?
Yes, Your
Hey,
Honor.
this case on our docket is styled People v. Wood. We've set it for 40 minutes, 20 minutes per side. Counsel for the people, begin when you're ready.
May it please the court. Your Honors, good morning. My name is Ryan Crane. I represent the people of the state of Colorado in this case. I want to just note to the court off the beginning here that we have victims in attendance, family members of the man that Mr. Wood killed in this case, as well as an employee who was present at the restaurant at the time of the robbery and murder. To begin with, this case, in fact, resulted from a clerical error. The double jeopardy violation actually did, in light of the transcript and the minimus that was issued, result from a clerical error, which is correctable under Crim P36 and our state's case law, saying that a minimus needs to actually reflect what was orally pronounced at sentencing.
I have to jump in, Mr. Crane, and ask, I mean, you make a pretty compelling case that this is clerical error. Why does it take 10 years and go all the way to the U.S. Supreme Court and back before someone says this was a clerical error? It strikes me as very odd after 10 years or more of litigation to be now saying this is a clerical error. So help me, I assume Mr. Evans is going to get up and say, no, it's not. Help me understand why, and maybe just nobody thought of it, but it strikes me as very odd after 10 years to say just fix a clerical error.
It is odd. I agree, Your Honor. And I would at least note the issue that it went to the Supreme Court on was not the clerical error or the double jeopardy violation. But yes, it's certainly odd. I can't argue with that. And all I can say is the focus has been on what the minimus actually says, which is correct in the sense that that's the operative legal document. And so that's what the 10th Circuit looked at, correctly so, and that's where it found the error. And so the transcript is not a legally operative document, but you know, at a certain time, someone looked at this and said, actually, I don't think that's actually what was entered on the minimus. That's not the same thing that occurred. So I don't have a good answer for you, Your Honor, other than this is what we've noticed, and I'm trying to just be upfront with the court and say, this is what we've seen, and if the court can find no other way to agree on anything, it could at least say, this actually is a clerical error, and it resolves the double jeopardy violation.
And would we just look at the transcript of the sentencing to decide it was clerical? Everybody agreed what was supposed to happen, and that's not what got on the minimus. Is that what we look at?
Yes, because the issue is what was actually written down on the minimus doesn't reflect what was orally pronounced by the district court. But of course, that leaves the more interesting question, and the more interesting question does have to be addressed, because even if the clerical error were corrected on that basis, we're going to be left with a Court of Appeals opinion that creates many problems for our state criminal justice system and wreaks havoc in certain limited cases, but in severe ways.
Is that necessarily true? I mean, if we were to agree with you that this is correctable under Crim P36, could we not simply vacate the remainder of the Court of Appeals opinion? Does that take care of your concerns?
I have thought and talked about this with colleagues to figure out, is there a way that that's possible? And all I can say is reversed, but I don't know how it doesn't end up continuing to be cited for what it stands for, with a citation saying vacated on other grounds or reversed on other grounds, in which case it's still going to be cited and the question is going to have to be addressed. I don't know if that makes it technically legally binding anymore on the district courts. I don't know. But it does leave in place an opinion that's going to be cited for this proposition by defendant we believe is very incorrect from continuing to be cited, and just with a vacated on other grounds or other grounds sort of note with it. And so the three problems that this Court of Appeals opinion creates are, at least number one, any defendant in Colorado who gets a conditional habeas corpus writ granted by a federal court will essentially be able to sit and wait until he's released. This case is actually more limited in the sense that the remedy ordered just vacates one of two convictions. The normal course is that the federal court orders release or retrial, if not within a reasonable period of time. And so we're going to have defendants, even though it's rare, it does happen, and we'll have defendants saying, I get to go free now because under this Court of Appeals opinion, our district courts have no authority to act on a federal court declaration of federal constitutional error. They can't do anything. Their hands are tied. They have to just sit and wait. The second error is the second problem this will produce is the Court of Appeals opinion essentially gave credence to the defendant's argument that by challenging only one conviction, he says, under a double jeopardy claim in federal court, he was able to choose which conviction he wanted vacated at the end of the day. he was essentially able to choose the remedy. Even though that's contrary to this state's case law and this court's case law, the Court of Appeals gave credence to that argument by saying, well, that's actually the only one he challenged in federal court. Third, I would just say, as another and final note, under the Court of Appeals reasoning, even the prosecution couldn't go in and ask for the court to fix a constitutional error that it found sometime down the road. Even if a defendant, let's say, was time-barred and successive and could not anymore raise a claim, the prosecution, even if it recognized and in the interest of justice wanted to go into the court and say, we actually believe, district court, this error has been identified late in the day, and in the interest of justice, we concede and believe it should be corrected. That's a rare situation, but the prosecution's burden, and my burden, this court's, is to do justice. And a prosecutor couldn't even do that under the Court of Appeals reasoning here, because it held, well, the prosecution could file a motion, but our district courts are powerless to do anything, essentially because there's not a protocol saying exactly how a district court is to proceed. So our position is the Colorado Constitution grants our district courts general jurisdiction in criminal cases. Our courts are also, under the federal Constitution's Supremacy Clause, bound by, in fact, the Supremacy Clause even says the judges of the states are bound by this Constitution, and it is the supreme law of the land, any state law or state constitution notwithstanding. Our position is, given that, and given that our Constitution creates the district courts as courts of general jurisdiction, they have both the duty and the authority to correct federal constitutional errors. When a federal court, which is supreme in matters of interpreting and applying the federal Constitution, declares, hey, Colorado District Court, you committed a federal constitutional error in this case, and it must be fixed. So I would clarify, this is not a situation where a district court just discovered some error on its own and wants to do something. This is not, that might raise questions of party presentation. One party maybe withheld a claim at a different time, latches because the prosecution has now gotten rid of evidence. This is also not a case where it doesn't depend on whether the federal court is actually ordering the state district court to do something. That never happens. The federal district court says, State of Colorado, you release this person because the conviction is unconstitutionally obtained, or you retry him, but we're not going to meddle in state affairs and tell you exactly what to do. We're going to give you the option. So the limiting principle essentially is you've got a federal court, which is superior in these matters, declaring an error has occurred in this case and some action must be taken.
Why do you think a federal court is superior in these matters?
Well,
it clearly would be with regard to an order, but you're saying the federal court did not order us to do anything, and yet you seem to be saying we're bound by an inferior federal court's interpretation of the Constitution. Is that what you're saying?
Well, our state is bound by the federal district court's order interpreting the federal Constitution with respect to this.
Do you think so?
Yes, I think so.
Not an order for us to do anything, but rather its interpretation of the Constitution.
Are you asking, and I'm just trying to clarify, is the question where does the authority come from for the state district court to act if there's not a direct order saying do this?
Well, not exactly. I'm hearing you make a distinction between what the federal court has ordered us to do and the federal court's interpretation of the United States Constitution. And maybe I'm mistaken, but I seem to be hearing you say that we are bound by the federal district court or even the 10th Circuit's interpretation of the federal Constitution. And I'm asking you where you think that comes from.
Well, the Supremacy Clause and the fact that the federal district court has a superior ability to and power to interpret the federal Constitution.
So you think the proposition you're stating is that the inferior federal courts construe the United States Constitution for the state court?
If they declare what the federal Constitution says, that's binding on what the state courts say, yes.
Okay, and you don't seem to be having any authority to support that, but I'll not argue with you if that's the proposition you want us to rely on.
I believe that's correct, just as the state courts would be superior to the federal court in interpreting state constitutional and statutory provisions, and the federal court can't quibble with what this court or our state courts do with respect to state interpretation or interpretation of state law.
Didn't the federal court recognize that it can't order the state court to do anything? That's why it's a conditional habeas order. And so I think the question comes down to where you started in response to Chief Justice Coates' question. What's the hook? And you start with 13.1.115 in your brief, and I have to say I'm struggling to figure out how that fits here, because I don't think this is a writ. So is it inherent authority? I mean, help me or make the argument on 13.1.115 if you can, but I'm curious let's assume, for purposes of my question, the federal court cannot order the state court to do anything. It just says, you can take it, so then the government raises it in the state court. What's the hook? And I don't think subject matter jurisdiction is enough. Of course, we have subject matter jurisdiction. You have to have a reason to walk into the court.
Right, so I guess when our state constitution, which is under the federal constitution, creates courts of general jurisdiction, those courts are empowered to decide criminal cases when it grants general jurisdiction over criminal cases. They're also bound and therefore empowered by our state constitution. Implicit in their creation as courts is an inherent authority to enforce and an obligation to enforce and abide by the federal constitution. So in that sense, the authority comes from the state constitution. It comes from state sources of authority that grant the court's jurisdiction. It doesn't depend on a federal court saying you have to do this or you have to do that. What the state court should do in a case like this is recognize there's a declaration of error. It's duty bound and must therefore act to comply with the federal constitution. It can't violate the federal constitution. Whether that's under 13.1.115 or inherent authority, we argued both in our brief, and I think the question here is not what the right result is. I think the real question is what conceptual box do we put this in so that it's not too expansive or too limiting. And so however this court believes those apply, I hear you saying 13.1.115 doesn't seem to be applicable. I think inherent authority, in my mind, is a more applicable phrase. But that's what it comes down to, is either way we want to look at it, there's an inherent authority that our courts have and a duty to abide by and enforce and not violate the federal constitution. And they should do so in accordance with state law. So for example, to the extent they can, because they're bound by this court's precedent saying when you merge convictions that are under double jeopardy, you don't retain the lesser conviction. You give the most effect to the verdict, both of which in this case were constitutionally obtained.
If, in fact, this was a mere clerical error, meaning based on the transcript, the intent was to merge all the convictions into the felony murder conviction, was there even a double jeopardy violation here that needs rectification?
There was, only because the 10th Circuit properly focused on the minimus as the operative legal document. So you can't take a transcript into court and say, look, here's my conviction. So no matter what the transcript says, if the minimus ends up saying something that violates double jeopardy, that's the document that we look at. Does that answer the question?
So
there was a double jeopardy violation because at the end of the day, the minimus says you're convicted of 2 different murders.
But isn't the basis of your argument that there was a clerical error, meaning that, in fact, the fact that there were convictions, there were no judgment of conviction ever entered because only a single sentence was ever imposed?
Well,
so there was no judgment of conviction on the other 2. We just need to clean this up. As a operative matter, only one judgment of conviction entered, only one sentence entered.
Well, the 10th Circuit's reading of the minimus was there were 2 murder convictions entered. And so our argument has been that's actually not what the district court judge ordered, but that's what ended up on the minimus. And those are operative legal convictions because they're on the legal document which defines what this person was convicted of.
And are we bound by the 10th Circuit's reading of the minimus?
We're bound by the 10th Circuit's ruling. The court is bound by the 10th Circuit's ruling that this is a double jeopardy violation. And that's really what,
Even if it's based on a mistaken factual premise?
well, that's not the situation we have here. I mean, the situation we have is the minimus, as it was originally, is at minimum ambiguous as to what the convictions were. It seems to say at the same time the convictions are merged, but that they're merged only for sentencing. There's a life sentence, but it continued to list dual murder convictions, which this court has said is not what the legislature intended.
And I guess I'm just trying to reconcile that with your argument that in fact this was nothing more than a clerical error. That in fact, that was never intended. There was only one judgment of conviction ever intended by the court.
That's all.
The minimus just says something different.
Right, and so the minimus resulted in the double jeopardy violation because that's what listed, it still continued to list 2 convictions.
In other words, the minimus shows there's 2 convictions of 2 murders, and it effectively shows a sentencing on both of those convictions, so we effectively have judgments on both convictions. And what you're saying is at least one of them should have been vacated, or the minimus should have said, gotten rid of one of them.
Yes.
So you don't have 2 convictions showing and suppose, or can be read to be sentences on both.
Right, because legally speaking, it doesn't matter what the judge ordered on the transcript if what we ended up with was a document that says you're convicted of these 2
And the
counts.
judge's intent, in your view, was to merge the second degree into the first degree and a sentence for life, and that was the intent. So we would have just the one judgment of conviction for the first degree.
Yes, and that's what the parties agreed to as well, and I'll reserve the remainder of my time if I may.
May it please the court. My name is Mark Evans, number 40156. I'm a public defender here today on behalf of Patrick Wood. What I'll plan to do here today is to start by addressing the Crim P36 argument and then getting to the real merits of this issue. Begin by explaining how limited the legal issue before this court today really is, explaining why in those limited circumstances the sources of authority proposed by the state don't work, and then end by explaining why the authority that did govern in this situation did not permit the trial court to vacate 2 convictions at the state's request. Turning to the Crim P36 argument, I do want to point out to the court that the state is effectively taking a position before this court that is directly contrary to the position it took in the Adams County District Court after this case returned from federal proceedings. Looking at page 376 of the court file, what renders Wood's convictions unconstitutional is the combination of the felony murder conviction and the second-degree murder conviction. The state has understood this case in the proceedings that got us here to involve 3 separate convictions, albeit 1 sentence, and the state should not now be permitted to take a directly contrary argument before this court. Now, that said, I do agree with the state that if this was clearly a clerical error, of course, a court can correct something that's clearly a clerical error at any time, but this was not clearly a clerical error. The trial court's actions and words on the final day of trial illustrate that although it was only imposing 1 sentence, it was intentionally entering 3 convictions. It filled out all of the verdict forms. It said, so there being only 1 sentence involving counts 1, 2, and 3, and then it added, I'll run the menacing counts 4 and 5 concurrent with the other counts. And that's what the minimus shows. It shows 1 sentence, but 3 different convictions at issue here. And that's why the 10th Circuit rejected the state's argument that there was only 1 conviction, and presumably why, when the case returned to Adams County, everybody was working on the assumption that there were, in fact, 3 convictions. So finding at this point that this was simply a clerical error would be contrary to the prior findings of both the federal and state courts in this case, and I believe is well outside of the type of unambiguous discrepancy that falls within the purview of Crim P36.
Mr. Evans, I just have a factual question. Forgive me, I'm just not remembering. Did the court at sentencing talk about merging the 3 convictions, or am I just misremembering?
Your Honor, court clearly intended to merge them for purposes of sentencing, hence it imposed only one sentence.
And did the court use the words merging for purposes of sentencing, or did the court say they all merge into the first-degree murder conviction?
The court, well, Your Honor, really all I have to go on is the two little quotes that I
understand.
that I just read. And what I take from those quotes is that the court was intending to enter 3 convictions, but only one sentence. And again, if the court were absolutely clear in the transcript what it was trying to do, and the minimus was clearly contrary to that, then I agree, that would be a clerical error. But I think there has to be a pretty unambiguous discrepancy there in order for Crim P36 to come into play.
What does it mean to enter a conviction without a sentence? Is that legal?
It is, Your Honor, and I think I don't think that that's unheard of at all, but...
We have provision for entering a judgment of conviction, but not requiring a sentence?
Correct, Your Honor, and that's exactly what happened in this case.
And do you think that would be a violation of due process in any way? Let me back up and ask. We have, at times, decided that more than one, for instance, in homicide, more than one conviction for killing the same person cannot enter. But I thought we'd gone to some lengths to say, and therefore we'll come up with a way of noting the jury verdicts, but without entering more than one conviction. I take it you're saying you think there is authority for us to enter more than one conviction, but simply not sentence.
Your Honor, I think that there is authority, generally speaking, for a court to enter a conviction but not impose a sentence. But what the court can't do is enter multiple convictions for the killing of a single victim, multiple homicide convictions, in what happened in this case, which the 10th Circuit recognized was a double jeopardy violation. That's the constitutional right at issue.
Okay.
And when you're talking about convictions, you mean judgment of conviction, correct?
Correct, Your Honor.
And don't our criminal rules require for entry of judgment of conviction for that to also include a sentence attached to that conviction?
Your Honor, I understand the way the rules of criminal procedure define a conviction, but what the United States Supreme Court has held and what the 10th Circuit recognized in Mr. Wood's case was that even in the absence of a sentence, simply having multiple convictions appear where those multiple convictions violate the double jeopardy clause is in fact a double jeopardy violation that has to be rectified.
Well, let me ask you the same question that Justice Samora asked your opponent, and that is, are we bound by the 10th Circuit's interpretation of our own MIT, of a state court MIT? Obviously, it didn't originate from this court.
Your Honor, I have not argued in the briefs, and I can't make an argument standing right here that this court is legally bound by that interpretation. What I can say is that a now Justice of the United States Supreme Court looked at the record before it and reached the conclusions that it reached. And what this court is bound by is the end result of the federal court's determination that if one or the other doesn't go, then the felony murder conviction is vacated.
Perhaps that could be a good place for you to explain why, since the federal court said if one or the other doesn't go, nevertheless you're arguing that there was only one option, despite what the federal court said.
Absolutely, Your Honor. So the federal court didn't address what the state court had the ability to do. And I want to start the conversation here by recognizing how limited of a factual situation that we're looking at here. And there is no dispute here that the Adams County District Court had the ability to fix a constitutional violation found by the federal courts. And the Court of Appeals opinion doesn't call that into question at all. This case is only about when a federal court identifies a constitutional violation, and that constitutional violation can be fixed either by vacating one conviction or by vacating a different set of convictions. I can't think of any context in which that's going to be the case other than double jeopardy. And most of the time, if there's a constitutional violation associated with a conviction, it's that conviction that has to be addressed to fix the problem. So the facts present here, a court identifying a federal constitutional violation, a defendant seeking to remedy that violation by vacating one conviction, and the state seeking to fix the violation by vacating two other convictions, is a rare set of facts indeed.
What do we do about the fact that the federal court in the conditional habeas specifically gave the state court the option to vacate a different sentence? I mean, the federal court says vacate this one, but unless you want to vacate the other one. I mean, I'm paraphrasing, but the language in the federal order says the district court, state court could do something other than, could choose which one to vacate. Just said one of them, they both can't exist. I mean, didn't the federal court your argument is you got to vacate the felony murder because that's what the federal court said, but I don't know that it did say that.
Your Honor, my argument isn't that you have to vacate felony murder because that's what the federal court said. My argument is that the state court can only act in a way that's authorized by state court authority. Yes, it's true. The 10th Circuit and the federal district court gave Colorado state courts the option. It said, listen, you can fix this problem one of two ways, but it didn't address whether the state court had the authority or the ability to take either of those two paths. It just said there are two things you can do that will prevent us from issuing the writ.
And maybe I just misunderstood, and I apologize. I thought you were acknowledging the state court does have the authority to fix an unconstitutional judgment.
Yes, it does, Your Honor, and it had the authority to vacate the felony murder conviction in this case.
So why didn't it not have the authority to vacate second-degree murder instead?
Because, Your Honor.
Sorry if I missed it. I
Right,
apologize.
because the court's authority here was defined by Crim P35 and the associated statutes, 16.5.402 and 18.1.410. I don't think that Colorado's All Writs Act and ancillary authority and inherited authority has any place here because the court's authority was already defined by Crim P35 and those statutes. And those statutes provide that only a person convicted of a crime has the ability to seek relief. They contemplate the district court entering relief, such as vacating and setting aside the judgment. And neither the statute nor the rules allows a court to grant a state's request to vacate a different judgment of conviction than what's addressed by the defendant. And absent circumstances not present here, a court can't grant relief for any conviction that's outside of the time limitations established by 16.5.402. That's likely why the state did not assert in the trial court or the Court of Appeals or in its opening brief before this court that those statutes in Crim P35C allowed the district court to vacate two convictions at its request years after the limitations period had passed.
But now I do understand your argument. So when we have a federal court order that says this conviction or judgment was unconstitutional, why wouldn't a court have at least the inherent authority as part of its inherent authority to enforce its own lawful orders to fix it, regardless of who asks?
Two reasons, Your Honor. Because the inherent authority doctrine does not apply when a court's authority is already established in other statutes or rules. We see that in Board of County Commissioners for the 19th Judicial District and the Pena decision. And this is a situation where that authority is already defined.
But you're assuming that because there are rules that give the defendant the authority, that means there is no authority of the state, and I guess I'm taking some issue with that. There's no rule one way or the other, arguably, of what the state does in this situation, hence the court can act. I'm throwing that out at you.
Right, but Your Honor, the statutes and the rule that we're talking about here aren't called defendant's limitations for collateral attack upon a judgment or defendant's post-conviction remedy. They're just addressing post-conviction remedies and limitations on those post-conviction remedies for anyone. And I think what's really important to recognize here is that to the extent that the court perceives what the law requires here as a problem, that problem has been fixed. The circumstance that arises in this case arises because prior to 2004, defendants had the option of either pursuing claims via CRIM P35 or direct appeal. Right now, if you want to bring, I can't think of any circumstance in which this sort of problem is going to arise other than double jeopardy. And if a defendant wants to make a double jeopardy argument, now he has to do it on direct appeal. And if he doesn't do it on a direct appeal, then it's gone.
Could I follow up on your double jeopardy point, just to ask this way? I'm understanding from your argument, both in brief and now, that you seem to feel that a double jeopardy problem, error, can be corrected only by granting the relief that the defendant asks for, that is, with regard to a particular crime. And you seem to also be suggesting that someone else would have to have the ability to challenge another crime that was part of the double jeopardy problem. Why isn't it simply that if the defendant challenges his convictions, maybe he chooses one to label, but says as a result of a violation of double jeopardy because he was convicted of more crimes than he was allowed to be convicted of, why does it not follow that the judge could fashion the remedy that would relieve him of the unconstitutional violation and still comply with state law to maximize his sentence?
So, Your Honor, if somebody wants to assert a double jeopardy violation today, or really any time post-2004, they have to do that on direct appeal. And on direct appeal, the appellate court has the authority to vacate any conviction under Colorado Appellate Rule 35. What makes this case unique is that in this case, the trial court's authority was limited to the authority granted by CRIM P35 and the associated statutes. And yes, my argument is, based on the language of the statute and on the rule, the court has authority to grant relief for the conviction challenged by the defendant. Now, again, most of the time, both in CRIM P35 land and in federal habeas land, that doesn't present this sort of issue because the defendant is challenging one conviction, and if there's a constitutional violation associated with that conviction, that's the conviction that has to be addressed. You only have this issue arise in the context of a double jeopardy claim, and only in the context of a double jeopardy claim where the limitation period for seeking post-conviction review expired before 2004. So what the state is asking to do here is to make up authority for the court to act that it simply didn't have. And I understand the temptation to do that based on the somewhat counterintuitive result that the law requires in this case. But the real danger here is taking a case with extremely unique factual circumstances, including the Lashes argument that was never ruled upon by the trial court, and expanding trial court's authority beyond the bounds of what's provided by the General Assembly and the rules of criminal procedure. That's the danger in this case. If the law operates the way it should here, Mr. Wood will still stand convicted of murder, and he will still serve an extraordinarily long prison sentence. The injustice here would be permitting trial courts to operate beyond the bounds of their authority. That's what poses a danger for both the state and defendants in the future.
Mr. Evans, can I shift gears with you a little bit? What's the legal effect of merger?
Well, Your Honor, it depends upon the circumstances. I think that there are circumstances where two convictions can be merged strictly for purpose.
And specifically here, if the felony murder was merged with the second-degree murder, what's the legal effect of that?
If the court had intended to merge the convictions, then I think that, that we wouldn't have a problem here, that there
Well,
wouldn't.
let me just, in the transcript, the judge said, well, obviously counts 1 and 2 on the murder counts merge, and they merge also with the aggravated robbery counts. Why doesn't that remedy this?
Your Honor, because read as a whole, what the transcript reflects is that the court was only merging for purposes of sentencing, that the court did intend to enter 3 convictions for the 2 murders and the aggravated robbery.
The next sentence is, so there being only one sentence involving counts 1, 2, and 3. So he said one sentence, and he used the word merge. Why does that not remedy this?
Because of the follow-up, Your Honor, because of the follow-up for counts 1, 2, and 3. And the court is indicating that counts 1, 2, and 3 remain viable counts of conviction, albeit with only one sentence for the 3 of them.
And where are you getting that?
Your Honor, from the same sentence that we've just been talking about,
I'll read the whole paragraph. It says, well, obviously counts 1 and 2 on the murder counts merge, and they merge also with the aggravated robbery counts. So there being only one sentence involving counts 1, 2, and 3. And the court would just impose a life sentence as provided by law.
Right, Your Honor. And I think had the court indicated that its intent was to not have counts 2 and 3 enter as judgments of conviction, then we wouldn't have the double jeopardy problem. But I think that what the court said indicates that it was simply merging the sentences, that the actual judgments of conviction remained viable.
All right.
But the only count that was even eligible for a life sentence would have been the felony murder conviction, correct?
That's correct, Your Honor.
And so the other counts wouldn't have even been eligible for a life sentence. I mean, there's no sentence attached to those other 2 convictions, is my point.
Correct, Your Honor.
So how can is it not possible then to infer from that what the court meant was that there would be literally a single conviction and a single life sentence for the first-degree murder conviction?
I see I'm out of time. Can I answer your question, Your Honor?
Please,
Okay.
if you can.
I'll do my best. Your Honor, I understand that looking at the transcripts, reasonable minds could look at that transcript and say, well, maybe the court intended 3 convictions in one sentence, or maybe the court only intended 1 conviction in 1 sentence. But as long as reasonable minds could differ, and obviously, I think when you look at it, what the court intended was 3 convictions, 1 sentence. As long as reasonable minds can differ, then it's not an unambiguous clerical error. That would be expanding the scope of Crim P36 to try to guess what the court meant and correct the error that way. But
Thank you.
thank you. I'd respectfully ask this court to affirm the Court of Appeals.
Thank you. Mr. Crane, I think you got a little time.
A little bit, thank you. So I guess the 2 points I'll try to make is, just real quickly, Crim P36 and 165402 do not address themselves to anyone. They address specifically to defendants bringing collateral attacks and defendant post-conviction motions. The court is correct that the statutes and rule do not address prosecution bringing these types of motions. Chief Justice Coates, I want to address your question because I think I now see the distinction you were making, and that is state courts are generally only bound by the U.S. Supreme Court. For example, in direct appeal, they're not, we don't direct appeal after this court and go to the federal district court or something. So maybe this addresses the issue, and that's that I'm not sure, maybe it's a different thing to say that our state court is not bound by what the federal district court could do in interpreting the Constitution. But what our state courts do have a duty to do is protect our state court convictions under our state constitution, and they are duty-bound when the federal district court says, we have found a federal constitutional error, and you're either going to release the person, in this case, delete a conviction or retry the person, or somehow fix the error. So maybe it is too far to say that this court is bound by a federal lower court's interpretation of the Constitution. But what our state district courts must be empowered to do is to act in a way that respects the federal court's order, which is saying, here's what's going to happen to your state conviction. What our courts can't do is say, well, we disagree with you, federal district court. We don't think there was a constitutional error at trial, because then the federal court can still order release of the prisoner at the end of the day, even if the court were to say, we actually disagree with this interpretation of the Constitution, but in any event. To address one other question was, I think it was Justice Marquez you brought up, perhaps our court could disagree with the 10th Circuit's interpretation of the minimus and fix the error in the sense of saying, the 10th Circuit read it this way. It did clearly read it to be somewhat ambiguous, but said the Colorado courts have treated these as dual convictions. I think this court could say, the minimus actually reflects only one conviction. This is how our Colorado minimuses look. And this is what they say when they enter only one legally operative conviction. The 10th Circuit may not have understood it, but here's what it means.
Thank you.
Thank you, Your Honor.
Thank you. Appreciate the arguments of both counsel. Case will stand submitted, and the court will be in recess until 1:30.